Hi, good late morning, everybody. I'm Debra D'Agostino. I'm a founding partner of a law firm called the Federal Practice Group. We're a sort of boutique law firm in Washington, D.C., and we represent federal employees almost exclusively on our employment law team as well. We have some other practice areas, but what we're going to talk about today certainly concerns federal employees, specifically Department of Education employees. We are going to be recording this webinar, so I know that there was some short notice on the announcement for this. We'll be able to circulate the recording. We're also going to keep our Q&A link open all weekend. So if people do have follow-up questions, please feel free to ask them. We can either set up another webinar, in a later time to answer those, or do an FAQ that we can post to our website. But please do keep asking questions. We're happy to answer them. Like I said, this is to talk about the Department of Education RIF, which is unique in a few ways that we'll address. So what I want to talk about today really are your rights in the RIF situation. So, the legal challenges that have already been raised, things that are pending, options that you have, and what those options look like. So I'm going to try to get through that succinctly. I know it's pretty, it's some niche stuff and some complicated stuff that folks just aren't used to. I know now you're all far more educated than you were a few months ago, but unfortunately, I should say. But I know it's nothing that really has come up, since the 80s, right? So it's hopefully nothing that any of you have dealt with before. And so the case law is certainly unique, and just some of the concepts are a little bit unique. But so there is some federal litigation. I'm sure you're all aware of that concerning the RIF, specifically at the Department of Education. There's one case, State of New York versus McMahon, that was filed in the district court in Massachusetts. The most recent action on that is that on September 15th, the First Circuit dismissed the appeal, as the district court stated, that it would vacate its previously issued preliminary injunction staying the RIF. So that's why Ed was able to go ahead with the RIFs and did separate you folks, deriving from what's going on in that case. At the district court level, there are motions now about discovery, and so it's going to be a long haul process. That case is going to go through the normal litigation track. So it's going to be litigated at the district court. It is surely to be appealed to the First Circuit, and almost surely also likely appealed to the Supreme Court. And that's going to take a very long time. Possibly it gets on the docket for this term, meaning a Supreme Court decision next summer. Possibly it does not. It still is at the district court level. So it's not implausible that that case could go on for some time. There's another case, Carter versus Department of Education, that's in the district court in DC. And that concerns the RIF only as applies to Education's Office of Civil Rights. So in that case, it looks like in late August, the parties filed a joint status report saying that the preliminary injunction remains in place. So those court cases are both going to continue, and obviously based on some other RIF litigation we've seen, no one thinks that the Supreme Court is likely to tie this administration's hands too tightly on these RIFs, unfortunately. But we do think that there is going to be room to look at how any given agency executed their RIF. So the doors is open, especially since with education, you guys do have a lawsuit concerning the RIF at education, as opposed to getting lumped in with several of the other agencies, like some of the other lawsuits. So my firm did file on behalf of two classes of education employees, class action appeals at the U.S. Merit Citizen Protection Board, called the MSPB, or I might also call it the board today. And so the first class was for non-bargaining unit employees of the Department of Education, minus the Office for Civil Rights and minus IES. We did file a separate class action appeal on behalf of employees of IES. Unfortunately, although not entirely unexpectedly, the board has declined to certify those classes. It's certainly disappointing that that happened, but like I said, not entirely unexpected. Thus far, the board has not certified a single class of RIF appeals. So there have been multiple class appeals filed, HHS, OPM, GSA, some of the other smaller RIFs classes were attempted. At this point, it just does not look like the board is going to entertain class appeals, which in some ways is it's like they're making it harder for themselves. So I don't know why they don't avail themselves of the class action option for RIFs, especially since we are talking about one RIF that was done to all of you. So yes, there are nuances as the RIF applies to you specifically, but there's also big overarching legal issues that apply to everyone in the class. And so we were hoping that the board would certify the class and sort of deal with those upper level issues that impact everybody as an easy way to do it. But for reasons that they haven't really made known, they're not going to be doing that. And like I said, with the two class appeals we filed on behalf of Department of Ed employees, they did deny class certification. So what does that mean? So the orders denying class certification say that anyone in the class now has 35 days to file an individual appeal if they want to pursue relief at the MSPB. And so for, I guess, the broader group of education employees, again, excluding Office for Civil Rights, IES, and non-bargaining or bargaining unit employees, rather, I said that backwards. The deadline for individual appeals is October 14th. For those who were RIFed at IES, those individual appeals are due on October 17th. And we'll talk about, what an individual appeal is, what it looks like, what you need to do. But even though the board won't certify classes, what they are doing is consolidating the appeals for processing. And so let me rewind on the notion of consolidation. So with a class appeal, there's one appeal, there's class representatives, they're filing on behalf of everyone covered in the class. With a consolidated appeal, every individual person needs to file an appeal, and then the board sort of lumps them all together for processing. What we don't quite have full insight yet on is how the board is going to do this. And we've seen different regions handling this differently, which is maddening to those of us who do this work. It'd be really nice if we could get some clarity from the board on how this is going to go. And maybe we will someday, but right now it's a little bit all over the place. So right now it looks like the cases or the appeals filed by Department of Education employees have been docketed in the Washington Regional Office of the MSPB. And there, it does look like they are willing to entertain consolidating appeals by, even groups of employees represented by one law firm, as opposed to lumping together all Department of Education employees sort of en masse. It can be two different groups. It can be, a group of education employees represented by us, a group of education employees represented by another law firm, maybe pro se employees who are unrepresented by counsel are lumped together. That could happen. It looks like all of the HHS RIF appeals have been moved to the Western region, and have all been assigned to one judge there. And what that's going to look like is anyone's guess. So what we're pushing for is to have those appeals consolidated by sub-agency. Um, we we don't know yet what they're going to do, though, and we keep trying to get more information, and they're not being terribly forthcoming. They do say they plan to consolidate cases by the end of September, so I'm guessing probably September 30th we are going to get word about how they're going to consolidate cases. But it looks like it might be by sub-agency, but mixing together folks represented by different law firms, folks unrepresented, all into one big group. So I think as it relates to you guys, with HHS at sub-agencies, with you guys, it might be by office. Um, but we really don't know, because we don't know. We just don't have a consistent response from the board on how the appeals will be consolidated. And what we're doing, though, is filing motions to consolidate, where we're saying, this is how we think this case should be consolidated, with this group, and here's why this makes sense. And so for you guys, I think this is a discussion that, we're happy to have with all of you. I know I've seen various thoughts on how Department of Education cases could be consolidated. And, I don't know that there's a plain right answer. My dog is barking. I don't know if you all can hear that. Apologies if you can, but it looks like the pest control spraying outside, and that's why my dog's losing his mind. Apologies for that. But so we don't have. Sorry. All right. Well, we'll take this out of the video so you do not hear my giant golden doodle losing his mind. Anyway, so we don't know yet, but we hope to have insight soon. And when we do, we'll let you know. So if we start hearing about how HHS is going, we'll share that with you, so you guys can have a better sense of what will make sense. There is some advantage to kind of going a little bit later, because we will have the advantage of seeing what it looks like for other groups. But I'd say that we've also seen interest from the agencies in having these cases consolidated, because the agencies also don't want to be dealing with hundreds or thousands of individual appeals. So, ideally, and I know some Department of Education attorneys have already reached out. I mean, ideally, we could work with them and say, look, here's how we think this should go. Here's why. And if we get them on board for that, then I would suspect the judge would be more likely to agree if both parties are in agreement as well. We have also seen the board consolidating all the cases before one judge per agency. So like all the HHS cases are going to one judge at the Western region. All of the GSA cases seem to be going to one judge in the Dallas region. OPM cases are all going to one judge in the DC region. I expect education would probably stay in the DC region, but there's no telling. I will say they've picked great judges. So the judges that are processing these cases now are sort of the board's, top-notch judges, which is all we can ask for. And I do think it does make sense to have them with one judge, just so that you don't have one judge saying the competitive area was drawn correctly and another one saying it was drawn correctly, and then you have this inconsistency. So I suspect they will all be with one judge. Don't know yet who that will be, and don't know yet how they will be consolidated. But like I said, we're certainly open to having that discussion with you guys and thinking through what makes the most sense. No guarantee that that's what the board will do, but I certainly think it makes sense for them to hear from us about how that should look. And I will say with consolidated appeals, one perk is that everyone can raise their own individual claims and defenses. So, with a class appeal, for example, you can't say, I think I was riffed because of whistleblower retaliation or because of age or something like that. with an individual appeal that ends up consolidated, each individual employee can raise their own claims and defenses. So one person could say they think they were riffed because of age discrimination, and the board will have to adjudicate that claim for that person. Even if they're consolidated with 40 other appeals, it's not going to matter. Each person can raise their own claims and defenses. So that's I guess one perk of having it dealt with that way. Um, so who can file an MSPB appeal? Um, Probationary employees, trial period employees, employees who were forced into involuntary retirement because of the RIF. Employees who are in the accepted service or competitive service. It's a pretty, you know, it's the definition of employee when it comes to appealing a RIF is broader than the definition of an employee if you were appealing an adverse action like a removal for performance or something like that, where there's more limits. So probationary, trial period, accepted, competitive, all you folks can file. And we've gotten a lot of questions about the retirement piece as well. As I'm sure you know, if this impacts you, if you are eligible for retirement with a RIF, basically you are forced into it. And you basically have to fill out a form that says voluntary retirement application, but it's not, right? It is an involuntary action caused because of the RIF. So if that is your circumstance, then you can still appeal. That's sort of the reverse of the normal rule, I guess, that's applicable to the RIF situation. If anyone's got any questions about your individual circumstance on that, please let us know. Happy to take a look at it. The one exception would be if you took a VERA, so a voluntary early retirement authority retirement. If you have taken a VERA, then that is considered a voluntary early retirement, and you can't then appeal your separation. But that's really the only exception to that rule in this circumstance. So if you have discontinued service retirement, if you have, you know, whatever it is that they set you up for, if it was because of the RIF that you are forced into this retirement, it's considered an involuntary retirement and you can appeal. So to file an appeal, let's talk about that. So the MSPB has an appeal form. You just need to fill it out and get it filed. I know that sounds really simple. The appeal form does ask a number of questions. A lot of it is, pretty basic stuff. Some of it's a little bit trickier. There is, there is one question, box 16, that asks why you think the RIF was wrong, why you think it was illegal. What we've been doing is writing up a response to that and having folks write "see attached" in the box, and then we're attaching the explanation as to why we think the RIF was illegal, with that appeal. You also do need, we need the RIF notice that you were issued, and then any sort of notification that was sent to you concerning the effective date of the separation, if there was one. And those are all things that we need with that initial appeal filing. If for whatever reason you don't have one of those things, that's fine. We can explain that. But those are things we're supposed to upload with that initial appeal form. We do have to file these appeals through the board's e-appeal system, which is less than ideal. It is a it's a clunker of a system. I'll say that. They updated it a few years ago, and ever since then, it's been just really running slowly and ineffectively, and it's no one's favorite right now. We tried, there were some other firms as well, to file the appeals in hard copy. A big stack of them saying, here are all these appeals of this RIF, here's motions to consolidate that go with them. And the board said, no thanks, you have to upload them all into e-appeal. So it's just tedious because it takes longer than it should because the system just doesn't run well, right? I guess that's the bottom line. Um, but the plus of the appeal system is that you will get an email when the appeal's filed, right? So you get a sort of receipt saying we've received your appeal. And then it's been a few days, but usually within a few days, the board has been issuing orders docketing those appeals. So then you get another email saying your appeal's been docketed. And then you're given a docket number that goes with that. And then you can get everything else that either party files or that the board issues through that system. So you will get an email anytime either party files anything or the judge issues any orders. You can also just log into it at any point and see, what's been filed, see what's there. And everyone can set up any appeal account. I think we've got some instructions on our website on how to do that. It's pretty straightforward. Um, it really has been jamming up. So I'd say that it's been maddening, but it's probably been taking us like a half hour to 40 minutes to file any given appeal. Back before they updated the system and made it shiny and new, it probably took us 10 minutes to get an appeal in there, but it's taking a lot longer right now. And the board does have unprecedented volume. I'm sure everyone kind of knows that at this point, but usually they are just dealing with individual people who got removed or subject to a lengthy suspension for misconduct or performance. Occasional USERA issues or veterans preference issues, but they have been inundated first with the probationary employees appeals. The vast majority of probationary employees do not have the right to appeal their termination. So that just sort of clogged the whole thing up, and those are still getting processed. There's some argument that was really a RIF. It wasn't really just a termination. So it's just, that was sort of the first crush. And then since then, there have been crushes of RIF appeals being filed. But I will, to the board's credit, in my experience, they're the most efficient body you could get in the federal government. Their rule is that they want to adjudicate appeals within 120 days, and I have to say that in most cases they do stick with that time frame. Historically, anyway. Sometimes we get an extra 30 days to do discovery or something, but they move far faster than, say, the EEOC, for example. If anyone's had an EEO complaint, this can be a 3, 4, 5, 6, 7-year process. That is generally not the case at the board. They do move these things fairly efficiently. And even though they have this insane volume, it looks like they are still moving pretty efficiently. Like I said, it looks like they're getting these things docketed within a few days. They're trying to get these things consolidated within a couple of weeks. And then after that, so procedurally, what will happen is the appeals get filed. We will file motions to consolidate the appeals, and then the judge will issue some order about how the appeals are going to be consolidated. What will happen next is that the agency is supposed to upload something called the agency file. And that's supposed to include, I guess, the basic documents relevant to the appeal, right? So in this case, it would be the RIF notice, the decision, those sorts of things. I suppose any relevant, materials that are otherwise ordered by the judge. And then the parties both get deadlines to conduct discovery. And so the MSPB appeal process, it kind of looks and feels like you filed a civil action in court. It follows all the same processes and procedures. And we have the same right to discovery, really, that we'd have if we were in federal court. So we can send over interrogatories, we can send over requests for documents, we can take depositions. They can send the same to you. They can depose you. They could send you document requests, I suppose interrogatories. I don't really know what they're going to be asking you all, but who knows? And then we exchange responses, A lot of times we run into snafus with the government either not turning over what we requested, or doing something ridiculous like sending us 40 boxes of junk. Hard to say what will happen here, but I could see either scenario potentially happening. But we will have the right to request emails, communications between Department of Ed and OMB, OPM, Doge. What were the internal discussions? What were the discussions between any of the very office leadership and the secretary, or the office leadership and Doge, so on and so forth. Um, so we can request broad categories of documents. We can request, signal chats, all of these sorts of things. I mean, I guess to the extent those still exist, but chats, if you had an inner office communication system, those are supposed to be preserved. We really have very broad range to request documents, which I think are going to be fascinating here. I think especially with the way that Ed changed their org chart, right? So on March 11th, and I'm sure you guys know this, but that was the day that Education announced they were doing this RIF, also the day that they issue these RIF notices. Also on that day, though, they issued or they established this new org chart. And I'm sure some of you folks have seen it. We included it with our class actions. But what it does is sort of redraws the competitive areas. And so the competitive areas used to be sort of these big offices, and now they're these tiny little groups under these bigger offices. We'll talk more about that later on, but how do they decide who was going to go, who was going to stay? What were the considerations? Who was involved in that discussion? What authority were they relying upon? Were any of these functions transferred to other entities within Ed, outside of Ed? Who knows what? But we have very broad discretion to conduct discovery. After that, we can elect to either proceed to a hearing, which really looks and feels like a trial. Witnesses get up, take the stand. There's direct exam and cross exam and all those things you expect to see in a trial. Or we can elect to submit a legal brief instead of doing a hearing. What we would typically make that decision based upon is whether or not there are facts in dispute, or whether or not we just have a legal issue left. So there are some cases, your classic misconduct case, right? The agency said this person did X, Y, and Z. This person said, I did not do X, Y, and Z, right? And the judge has to decide what happened and who's telling the truth and who's not. In that case, we want to have a hearing, because how else are you going to establish that? There are other cases, I guess an annuity appeal is a classic example, right? Is this person entitled to service credit for this time when they were deployed or not, right? There's no facts in dispute. We know when the person was deployed. We know what authority they were deployed pursuant to. There's a question of, did they get service credit or not? It's really a legal issue at that point. We don't need to get any factual issues hashed out. What we usually do is, when we file the appeal, we do elect to have a hearing, because we really only get a limited shot to choose to have a hearing, but we can always withdraw that election. So, what we would want to do is file the appeal saying, yes, we want a hearing. And then if after discovery, it doesn't make sense to do a hearing, we can just rescind that and ask for a briefing schedule. And I do think it is going to be tricky in these cases to figure out what makes the most sense, because I do suspect there are going to be cracks in the track, so to speak, about what really happened and how these plans were really hatched. And then we'll have to decide, do those things really matter, right? Does that change the legality of the thing or not? And then after that, the administrative judge would issue a decision. I think I'm going a little bit out of order from my outline, but with the decision, it's what's called an initial decision. And if neither party appeals, then that becomes the final decision. but both parties do have the right to appeal. So as the appellant, the employee side, we have the right to appeal either to the U.S. Court of Appeals for the Federal Circuit, which is, one level down from the Supreme Court, or we can appeal to the board. So above the administrative judges, there is the actual board itself, the MSPB. And we would file what's called a petition for review, and we would ask the board to look to review the judge's decision, basically. And so the rub with this is that right now the board does not have quorum. There are supposed to be 3 board members. The law says there's supposed to be 2 from one political party and 1 from another. And Trump fired Biden's Democratic appointee to the board. Her case is going to be resolved by the Supreme Court probably next summer. There was another Democrat on the board. His term expired. There was no chance Trump was going to renew it. So he sort of left with the expiration of his term. So there is 1 board member left. He's a Republican appointee. Biden did appoint him. He previously was the special counsel, with the Office of Special Counsel, which deals with whistleblower retaliation. Honestly, we've all had nothing but good things to say about him so far anyway. He was fantastic for whistleblowers when he was at OSC. He's been solid while he's been at the board. He's just a reasonable person, is what we've seen from him. Trump did nominate another board member. It went to the committee in, I think it's like June 4th or something like that, and then nothing was ever heard from the committee again. So I think he was like a GS-11 Air Force attorney or something like that. He really did not appear surface level to be qualified for the job. And I have to imagine that even the Republicans on the committee said this doesn't look like this is going to be a great fit for this job. So it seems like it kind of died there. We don't know if there's going to be another appointee or not, or when that would be. But so if the board lacks quorum, what that means is that they can't issue decisions. So if someone appeals the administrative judge's decision, or if I should say, if some party appeals that, it's going to be sitting there until the board has quorum. So with the first Trump administration, the board also did not have quorum. Trump didn't nominate anybody. It was kind of maddening until I guess at the very end he did, but they never got out of the Senate. But so they then were dealing with, quite literally 5 years of backlog cases to get through once there finally was a board in place. Some of those cases are still sitting there actually, which is just nuts. But so if a party appeals to the board, our expectation is there's a very good chance it would be sitting there potentially for years. And as the appellant, the employee, we have the choice, like I said, to appeal either to the Federal Circuit or to file a petition for review with the board. I think there's some argument, but it looks like the agencies can only file a petition for review with the board. So what that could mean is that if we prevail, the government could appeal and it could end up stuck there. It's really too early to tell what that could look like, too early to tell if that's what they would do. But it's certainly something that's on our mind, and and something I want to share with you guys who are considering what options make sense for you. So let's talk some more about Ed's RIF in particular. So like I said, on the appeal form, you're asked why the appeal was illegal. And I'll share with you some of the issues that we raised in the class appeals. And I will say that you do have to raise these claims and defenses to have the right to, have the judge adjudicate them, right? So if in your initial appeal you didn't raise everything, you can still amend that and add new claims up to the pre-hearing conference, really. But we do want to raise everything we can. And so we did raise some of the constitutional issues in the class appeal. I don't suspect that the board is likely to issue decisions on some of these constitutional issues if it is very well known that these same issues are pending before federal courts. I suspect they will defer to the federal courts on those. But there's certainly a question as to whether or not the RIF done at Ed is ultra vires, and the gist here is that the RIF was directed by Doge, OMB, OPM, not Ed personnel, right? And only Ed personnel have the authority to make decisions at Ed. Um, and so that's a claim that's getting raised sort of across the board. All these rifts came about because Trump issued an executive order commanding agencies to do this. So that's certainly an issue that everyone is seeing as problematic with these rifts. Also separation of powers issues. Obviously, Congress appropriated funds for programs. You know, there are laws that say some of these programs have to exist, right? And when Congress appropriates funds for that to happen, what authority does the president have to come in and say, no, don't spend that money, or don't do this work? So, certainly several of those issues are present with the RIF at Department of Education. And then obviously a big issue is the way education carried out the RIF, right? So did Ed comply with federal law, the RIF regulations in executing the RIF? And this is subject to what's called the harmful procedural error rule. And the gist is that we have to show that any procedural errors mattered, right? So, you can't just say, well, they screwed up. I don't know, they screwed up some performance rating was inaccurate and it really should have been a 5 instead of a 4. And yeah, maybe they did screw that up, but it only is going to matter if we can show that it harmed you. So in a case like that, we could only have that matter if we could show that if they had given you the 5, that somehow you would have not been riffed in lieu of someone else, right? So here, where that's really relevant is the issue of how they drew the competitive areas, which I touched on a little bit earlier, but the regulations set out, right? They define what a competitive area is supposed to be. And it's supposed to be a big entity, right? It's not supposed to be some little office of 4 people. It's supposed to be, the office of 400. We've seen this across the government so far. Everything DOJ has put its finger in. The strategy has been to very, very narrowly define the competitive area so that you avoid having to do the retention register, so that you avoid having to rank everybody and figure out who stays and who goes. Instead, they draw the competitive area in a very small little bubble, and then they just get rid of the whole thing, right? And that way they say the entire competitive area was eliminated, and it doesn't really matter where you ranked on the retention register, which surely we screwed up, because everyone's gone in the competitive area. So I think the fight about how the competitive areas were drawn is going to be, really central for education, because, like I said, they did establish these new competitive areas on March 11th, which were much, much smaller than the competitive areas as they're defined in education's human capital policy, where it says here are the competitive areas. So there's in the human capital policy, there's, I think it's Appendix A, literally lists out these are the competitive areas at Ed. And those were not the competitive areas they used to carry out this RIF. Agencies are allowed to redraw competitive areas. They're still supposed to be drawn in compliance with the regulation, which I do not think they did here, but they're also supposed to do that with 90 days notice. It looks like, based on some of the stuff filed in some of the civil litigation, that they're going to argue that OPM gave them a waiver of that 90-day notice rule, but I still think the bottom line is these are very narrowly drawn competitive areas. And I got to think that the board is not going to agree that these competitive areas should have been drawn this narrowly. And that's, like I said, that's an issue we're seeing with everything DOJ touched. And it would be a harmful error because, you know, if the competitive area was drawn more broadly, then you actually would have to compete. You would actually have to see where people fall on the retention register and who stays and who goes. And you know, that, so far as I know, did not occur here. There's also, this is pretty unique to Department of Education, but the Department of Education Organization Act does limit the secretary's authority to reorganize the department, which is unique, right? Most agencies do not have that. And it looks like the organizational changes done through this RIF exceed the secretary's authority that was limited by that law. So I think that's going to be another fundamental argument here that could really matter. It's you know, obviously when education was set up, it did pull in some entities from other agencies, establish them under education. I know there are groups, IES being one of them, where there's additional arguments as to why the secretary's authority is limited to that group of folks. But it is something very unique to ed, and I have got to imagine that the board is going to look at that very carefully and closely, because it's it just looks like, you know, there's a limit and they exceeded it, right? So hopefully the board sees it that way as well. There are also issues, if we're dealing with consolidated appeals versus a class action, folks can raise issues concerning transfer of function, or what's called bump and retreat. I don't know who named it that. It's sort of a silly name, but transfer of function, the gist is that the agency kept the function, and if they do that, they're supposed to move you with it, right? So the employee performing the function is supposed to go with the function. So if they take the function from office A and move it to office B, they're supposed to move the employee from A to B, right? They're not just supposed to move the function and then fire the employees in office A. And that's supposed to be the case whether or not the function moves within the entity, within the department, or if it gets shipped to another department. That's happened historically as well. Bump and retreat concerns, you know, your sort of right to stay put versus another employee's. So they're supposed to create a retention register where everyone is ranked based on your tenure, your performance ratings, veterans preference, all those things go into it. And if they're going to be keeping some folks, you know, there's a fight over who gets to stay. And it's not supposed to be their favorites. It's not supposed to be people they plucked out before they executed the RIF to hide them somewhere. It's supposed to be done in a very specific manner, in a very specific order. This is something traditionally that takes agencies months to do, which is why we're all suspicious of whether they did it at all. I don't think that they did. I know there's been, you know, some agencies coughing up some retention registers when, you know, they're demanded to do so, but this really is something that's not easy to execute. I mean, you do have to, you know, you're supposed to start with the whole competitive area, right? And then break people down into competitive level, which is usually people doing the same job at the same grade. And then within each level, you're supposed to rank people. And how can that even happen if you define the competitive area so narrowly that it only has, you know, 12 people in it, right? I mean, very different if you're talking about 200 people versus 12. So those issues are ones that can be raised in individual appeals, and that the board certainly has the authority to adjudicate. Well, let me move on here. I know we had some of the questions you guys sent in. One question is, what happens if the board is dismantled completely? It is established by the Civil Service Reform Act, so it would take an act of Congress to undo that. You know, I have not heard that that's being discussed. Certainly couldn't rule it out, but I'd say the more likely scenario would be that instead of it being completely dismantled, it just becomes defunct, right? Like it stops working because, you know, Trump fires the last board member standing or something like that. Um, but if a federal employee does not have an administrative avenue for relief, which is supposed to be the MSPB in the case of RIF, then there is an argument that they can file a civil action in court. That is the last thing judges want to deal with. That's the last thing they want to see. So I'd say that there is pressure all around to keep these administrative bodies open and operating, because they don't want federal employees to be able to sue in court. Um, obviously private sector employees, if you're fired or riffed, you have the right to sue in court. But because of the Civil Service Reform Act, federal employees have to go through these administrative processes that were established for this purpose. And like I said, for RIF, that's the MSPB. What happens if the government files an immediate appeal to stall cases? They can't really do that. So they so that would be what's called an interlocutory appeal when, sort of before the whole case is over, one party runs to try to appeal. Um, there is some limited right to do that in the case of class certification issues, but so far that does not look like it's going anywhere. Um, I have not heard any inkling that the agencies intend to do anything like that. I don't think it would work anyway. Um, And I do think both sides can probably work together to figure out, where the case does need to be stalled. And so I guess what I'm getting at is uh we we don't think that it makes sense to be heading into discovery before the consolidation issue is worked out, right? Who's going to be lumped with who? That's going to impact what discovery we're doing, what discovery we're requesting specific to that group. We don't want to be heading into discovery and then later on have the judge say, "Oh, actually, I'm going to group you with these people." It just seems that both parties have an interest in getting that consolidation out of the way before we head into discovery. Um, I've, I'd say that I've gotten no pushback whatsoever from any agency representative on that. That they want same thing, right? I mean, they've wanted to not do discovery before class certification issues are resolved and so forth. It just seems all around that that makes sense. Um, but then, after that, there's very few ways either party can stall the case. I mean, um, the board just doesn't really have the mechanisms for the kind of endless delays you see, with civil actions in court. What can happen is that they're just going to be so burdened with volume that it's going to take forever to get these processed, and we certainly can't rule out that that could happen here. So, it's just really too early to tell. I think 120 days is going to be ludicrous. I can't see that happening here, just given what the discovery might end up looking like and the fights we might have about that discovery. Um, but how long it will ultimately take is really anyone's guess, unfortunately. But I would say I have faith that they're going to try their best to do this efficiently. Um, Also, a question about realistic outcomes of an MSPB appeal. So the relief that the board orders is a rescission of the action, right? So they would order the agency to rescind the RIF. And then with that comes a retroactive reinstatement. And with retroactive reinstatement comes back pay, comes back benefits. That includes, retroactive TSP contributions, includes, obviously retirement annuity withholdings and so forth. Um, the back pay is reduced by other income you earned in that period, right? So if the case is decided 6 months from now and you've been doing part-time work, the money you earned doing that part-time work would be reduced from that back pay award. Um, if you are collecting an annuity from OPM, then the agency would reimburse OPM for the annuity that they paid you. You don't have to deal with that that mess, but the back pay you get is reduced by the annuity that you received in the interim. If you apply for unemployment and collect that, that's also going to be withheld. The agencies all have agreements with the states, and they withhold that from back pay awards and reimburse the states for that. And whether you go back or not, that's entirely your choice. So, I certainly understand people saying, I see where this is headed anyway, right? Like even if the RIF is rescinded for now, I don't want to work there anymore, or this is all going to fall apart with, who knows what. But it's always going to be your choice to go back or not. Some people go back and then resign immediately. They then do get the back pay, though. They do get the service credit, and the service credit's valuable, especially if this case goes on for a long time, right? I mean, if these end up going on for, say the board decides we're going to wait for the courts to adjudicate these constitutional issues before we rule, and that means these are sitting there for months and months and months. If you are retroactively reinstated, then you are getting those months and months and months of service credit, right, toward your annuity. And so that's certainly valuable. I would certainly tell anyone to take that, right? Why not? Even if you don't intend to go back, go back and then resign. But again, that's everyone's choice to do that. If the RIF is ordered to be rescinded because of a procedural error, they would, in all likelihood, be permitted to do it again in a procedurally correct way. So this comes up a lot with due process violations in cases, right? Your typical misconduct case, the first thing we're looking for is, can we find a due process violation? And if we do, and we prevail on it, then the board would order the agency to rescind the removal, and then the agency can do it again the right way. So we could certainly foresee a case where, if it is just a procedural flaw, that they could do the RIF again over the right way. I think that's easier said than done in this situation, because the competitive area issue is really so central to the way they did this RIF, and I think the problem with it. They would have to then really undo their new organizational structure, put the old one back into place, and then that's going to require them to do a real retention register, require them to really look at, transferring folks with functions, bump and retreat, and all of those things that, like I said, typically take agencies months and months to do. And so it could be that, it ends up taking months and months, or it could be that they've lost the appetite to move ahead with it. I know education's in a, sort of, I guess, politically unique situation, and that for reasons that I can't ever really understand, it's sort of a, political target of the administration. But if we're talking about getting months and months and months of back pay and service credit, again, why not take it? You don't get any damages at the MSPB unless you do win on a claim of discrimination or whistleblower retaliation. So far, I haven't really heard of those existing at Ed, but if that is an issue that's unique to you and you prevail on that, that's where you could get damages. But you would not get damages if there's a determination that the RIF was just done in a legal manner. You also do get reimbursement of attorney's fees. And just to touch on that, I know we're running out of time here. What we are looking at doing for these appeals is doing them on a flat fee basis of $500 an employee. So for that, we will file your appeal, file the motion to consolidate, deal with the consolidation mess, and try to, make the arguments about how we think it should be consolidated. And I would also suppose that if the judge issues a decision that we disagree with, also, filing a request for reconsideration, which, is now happening with some of the other agencies. So that would all be encompassed within that flat fee. And then once the cases are consolidated, we can go back to sort of a fee sharing situation. So, um, I wish we knew what that would look like so we could plan it a little bit better. But, if they do consolidate into all of ed, which is a possibility that I cannot rule out. I mean, based on what we've heard um, from some of the judges, there is a distinct possibility that they do consolidate all the cases from Department of Education, right? In which case, I'd say discovery is going to be a hassle because we got for many reasons, but what we can do is just sort of have a thing where people are chipping in fees, toward the whole, right? Um, if we do have smaller groups of folks, if the groups end up being consolidated into groups of, 20, 50, whatever, we can also work something like that out. Um, we do typically do this sort of work off of what's called a fee advance, which is really just like what it sounds. So in other words, we ask for the fees to be paid in advance of the work. We put that money into a client trust account, and then we withdraw against that on an hourly basis. um, there is going to be some discovery that's going to be universal, right? That is going to be, we draft the interrogatory and then it's used for all of you, right? And so, given that there's going to be duplicative work, that is going to keep costs down. Many of the arguments we're going to be raising, right? That how the competitive areas were drawn. That's an argument we're going to, well, we've already done the research on because we did the class appeal. But that's going to be something that we're not going to be charging each of you individually for that because it's sort of a shared thing amongst all of you. So that efficiency does keep costs down. We're also happy to work with you to keep costs down, right? So I know I've seen some comments come in about I already have some discovery requests written. We're happy to take those. We're happy to fold those in. Um, you know, if we do get discovery requests from the agency, right, we're happy to send those to you, have you guys do the legwork on that to keep costs down. So we're certainly open to looking at ways to split costs, to share costs, to keep it affordable. Um, and we do have, so for anyone who's interested in representation for filing the appeal and the consolidation, we do sort of have a packet of info for folks to fill out. That includes, an intake form where we're asking you questions about you, about what you think was wrong with the RIF. Representation agreement, which is, for that flat fee that I mentioned of $500. A link to pay that fee. A place to upload your RIF notice and decision, and all of that. We sort of have consolidated into a thing you can click through. We will send that out to everyone who registered for this webinar. We'll certainly make that available to anyone. And I see it is 11:58 and we are just about out of time. Um, like I started this session with, I know you all do have more questions. Please keep sending them to us. We can certainly set up a follow-on seminar or webinar where we're more honed in on some of the specific questions you have. We can also look at doing sessions with groups of you, right? If you are a group that has a unique issue, based on the statute, right, and the structure and the secretary's authority to reorganize your entity, we can likely set something up with you as a smaller group to address those issues specifically. So I know you all have so many questions because this is just, I'm sure nothing any of you thought you'd be dealing with if we rolled time back a year. Um, and I'm so sorry you're all dealing with this. I really wish I was not having to represent you folks in this, right? It is it's really unfortunate that you're all having to be victims of sort of some other fight that really isn't about you, isn't about the work that you did on behalf of the American people, which was valued work, and hopefully we can get you back to it. Um, So I thank you all for attending. And like I said, please feel free to reach out with questions and we'll be in touch. Take care.